Welcome to Verney Tax Law. The presentation today will address the options available to a taxpayer who is subject to an FBAR penalty assessment. What are your options in the event the IRS has proposed the assessment of an FBAR penalty or where the IRS has already assessed the penalty? Understanding the law that authorizes the assessment of the FBAR penalty, the procedural safeguards, and the time constraints is essential to protecting your rights. The assessment of the FBAR penalty is authorized under Title 31, not Title 26, the Internal Revenue Code. Consequently, you may not file a petition with the United States Tax Court to dispute an FBAR penalty since it is not considered to be a tax. Although the U.S. Tax Court is not an option, taxpayers are able to file an FBAR appeal with the IRS Office of Appeals. The appeals process is available both in the pre- and post-assessment phase of the penalty. As a condition to the assessment of an FBAR penalty, the IRS must issue Letter 3709. This is a notice of proposed penalty. A taxpayer generally has 30 days to respond and request an appeal of the FBAR penalty after receiving Letter 3709. If an appeal is not requested, the examiner will close the case and assess the penalty. The process for requesting an appeal requires submitting a written protest postmarked on or before the date listed on Letter 3709. The written protest must be submitted in duplicate and mailed to the revenue agent listed in the letter prior to the designated response date. In addition, you must also include a copy of Letter 3709 with your written protest. For your reference, I have uploaded Letter 3709 to my website. Drafting a written protest is complex. A protest letter must contain detailed information, citations to statutes, regulations, and cases, as well as an affirmation by the taxpayer that he or she is signing the protest letter under penalties of perjury. Accordingly, you should seek the assistance of an experienced and knowledgeable tax attorney. If the protest is considered invalid, the examiner will communicate the defects to the taxpayer. If there is sufficient time on the statute of limitations for assessments, the examiner will generally provide a reasonable deadline for the taxpayer to submit the corrected written protest. If there is insufficient time on the statute of limitations, the examiner will generally request the taxpayer sign an extension in which to assess the FBAR penalty. What happens if you do nothing? Well, if you do nothing, the penalty will be assessed and Letter 3708 will issue. This is a notice in demand for payment. The taxpayer has 30 days to pay the penalty. The letter also informs the taxpayer of the collection remedies available to the IRS. Letter 3708 provides the taxpayer with an opportunity to appeal by requesting an appeal hearing through the IRS Office of Appeals. Letter 3708 also advises the client that he has a right to file an action in federal court to contest the penalty and or the right to pay part or all of the assessment and file a suit for refund. If you do not take any action by the response date noted above, the IRS will begin collection process. Where the taxpayer fails to pay the penalty, the government will thereafter file an action in the United States District Court to reduce the FBAR penalty to a judgment. Based upon the foregoing, time is not your ally. If you receive Letter 3709 or Letter 3708, it is imperative that you act immediately and contact an attorney. Thank you for listening.